Joining me today on this webinar is Morganne Foley, a member of our immigration team and associate at the St. John, New Brunswick office. So Morganne's going to start this off for us. So Morganne, I'll leave it to you.
Perfect. Thank you, Megan. Well, like Megan said, we're welcoming everyone here today, and we're here to discuss 5 key immigration law compliance best practices for HR professionals. And I think it comes as no secret that the Atlantic region, there's been many reports of the worker shortage problem in the region. For example, the Francis McGuire, president of ACOA, the Atlantic Canada Opportunities Agency, has in a recent article said the region was moving into a labor drought. And I'm just trying to switch my slide here. There we go, perfect. So, like I said, famously, the several articles province-wide and region-wide that the Atlantic region is facing a labor drought and upcoming labor shortages ahead. We've been warned of labor shortages. Statistics Canada has reported that the region has more than 23,000 jobs without workers to fill them, or without workers with the requisite skills to fill these positions. And often we hear it talked about as an upcoming drought or shortages, but really for many companies, the crisis is already here. Big, small, regardless of the size of the company, many are already facing trouble finding the people that they need and the skills that they need in order to fill the positions in this area. And for many, the immigration is a solution for this problem that they're facing. So again, this was a National Post article entitled "How Atlantic Canada's Businesses Are Trying to Attract Immigrants" from May of this year. In it, there were several examples of industries given where they've faced challenges because of worker shortages. Ganong Brothers was one example. Obviously, a food processing industry where they were short workers and had trouble filling orders for its chocolates that they make here in St. Stephen, New Brunswick. Another example given was an owner of Tim Hortons franchises in Deer Lake and St. Anthony, Newfoundland, who he and his spouse were actually working themselves in their business because they were consistently short 5-6 employees at any given time. So, we of course see immigration, and there have been lots of reports on immigration as a solution to this issue, and there have been several organizations that are starting to recognize immigration as a solution. One great example was JDI this year made history when it appointed Susan Wilson as their first director of immigration. It's obviously a very large private company and has been recruiting overseas for a long time. But they had, the company had never before set up a department dedicated to the needs of foreign workers and an immigration-specific department. So this was really historic in the sense that it created this to specifically address the needs of foreign workers and to show a center of excellence that they launched in immigration at the beginning of 2018 to address this labor shortage. Of course, another example more generally is the introduction of the Atlantic Immigration Pilot Program across the Atlantic region. So the 4 provinces have developed an immigration stream helping employers recruit workers from outside of Canada. And a key piece of the Atlantic Immigration Pilot was the fact that it has a settlement component where employers are required to assist in the settlement of their employees in Canada. And another example of corporations kind of buying into the immigration solution is Day & Ross Transportation Group. Another example given in this article that I was speaking of was one of the first companies to actually bring workers to Canada using the Atlantic Immigration Pilot Program. 2 computer programmers as well as an IT specialist that they were able to bring in late last year. And just one other example came from the same article showing this need, I guess, for on-the-ground support for immigrants and the settlement support for immigrants is the Atlantic Ballet Theater. So they were demonstrating as an example of an organization that's been doing settlement-type services for more than a decade. So they're a Moncton-based dance company that really have perfected some of these best practices that the Atlantic Immigration Program is now encouraging other employers to adopt in terms of actually helping their, whether it's scouting apartments for their employees, helping with language courses, even picking them up at the airport, taking them to places like Service New Brunswick or Service Canada to obtain a SIN number, things like that, taking them to the supermarket, kind of that above and beyond settlement services for immigrant workers. So we recognize immigration as a solution. However, that in order to stay up to speed on immigration rules and participate in immigration as a solution, it can be tricky because immigration, of course, is a moving target. There are many, many changes that happen all the time, new programs and policies that are always being implemented. And these are just a few of the examples. So like I spoke of the Atlantic Immigration Pilot that was introduced in 2017 as a 3-year pilot program for the Atlantic region. Obviously a new program for employers to buy in. It's taken some time. Of course, we see now more and more employers who are getting involved, getting themselves designated under the program in order to participate and meet the targets for the numbers of immigrants coming in under the program. Another example is the Global Talent Stream, which is a program that was introduced in order to speed up some of the processing times associated with work permits, and particularly to assist in attracting workers in the tech industry and some specific job industries where there's been noted shortage of workers. The provincial nominee programs are another example of programs that are available in each province across the country, but each province has their own provincial nominee program with its own nuances and its own changes. Within each nominee program, there are various streams for which foreign people could be eligible, and those are new ones are being introduced, as well as previous streams may be closed at any time. So it's always important to stay up to date on which streams are available within the provinces separately, as well as the Atlantic region as a whole. Another aspect is international agreements. So we have CETA, which is the Comprehensive Economic and Trade Agreement between Canada and the European Union and its member states. That's a newly introduced international agreement, and we're seeing now more and more professionals, or intercompany transferees, etc., who are coming to Canada under CETA. NAFTA as well is an agreement that, of course, has been in place for some time, but is currently undergoing negotiations. There may be upcoming changes. It's a bit of a question mark for us now as to whether there will be changes to the foreign worker process under NAFTA. The one thing that doesn't change, however, regardless of the immigration streams that people are using to have employees come to Canada, is the compliance and immigration and enforcement aspect of the immigration applications. So regardless of the program, the employers must comply with immigration laws, and foreign workers must comply with the immigration laws surrounding each of the streams. And some examples of the consequences under the Immigration and Refugee Protection Act for employers who do not comply with the requirements of employers is, skipping ahead here. Jump to slide, yeah. So under the Immigration and Refugee Protection Act, like I stated, every person who commits an offense who employs a foreign national in a capacity in which that foreign national is not authorized to be employed. So it's important to note as well that the Act states a person who fails to exercise due diligence to determine whether employment is authorized under the Act is deemed to know that it is unauthorized. So there are requirements of employers to do their due diligence to ensure that they're employing a foreign national who is authorized to be employed in Canada. The penalties under the Immigration and Refugee Protection Act for failure to comply with the Act range from summary conviction to indictment. You'll see on the right side of the slide could range from fines to terms of imprisonment. So summary conviction, fines of not more than $10,000 or imprisonment for a term of not more than 6 months. When we're talking of indictments, fine of not more than $50,000 and imprisonment for a term of not more than 2 years. And regardless, I know Meghan's going to talk a bit about the nuances between the LMIA and international mobility program, so the temporary foreign worker program versus the international mobility program. But regardless of the program under which you're bringing an employee to Canada, there are 2 compliance regimes, one under each, but they both mirror their enforcement. So regardless of which regime you're complying under, your enforcement requirements really mirror each other. And in terms of compliance, there are potentially a random audits of the entire employer's organization or of specific employees who are there as foreign workers. It's also important for employers to comply by maintaining all records with respect to their foreign worker for a period of 6 years. On the enforcement side, failure to comply could result in the revocation of LMIAs or work permits, 1 to 5 year prohibition on applying for LMIAs, which is the Labor Market Impact Assessment, or on hiring temporary foreign workers in general, and also could result in the publication of the employer's name on a non-compliance list. So as I flip to the next slide here, we'll just see a screenshot of the ESDC, so Employment and Social Development Canada, has a website on which they publish names of employers who have been found to be non-compliant. So whether through an auditing process, what have you, then there we go. The employers who have been issued either a monetary penalty or banned from hiring temporary workers. This is a public list, publicly available on the ESDC website, and as you can see here, an example, it lists the name, the address, some of the penalties, etc., of that organization when they've been found non-compliant. Another example, jumping ahead, is this article here. It's an article from 2016, but it just demonstrates an example of an Edmonton woman who was sentenced and ordered to pay restitution in what was considered a landmark case involving the exploitation of foreign workers. So this woman was the first person in Alberta to be charged and convicted under the Immigration and Refugee Protection Act, and she was found guilty of employing at least 68 foreign nationals in a capacity that they were not authorized to be employed. And this was from the period of 2006 to 2010. So again, contrary to the Immigration and Refugee Protection Act, employing foreign nationals in a capacity that they were not authorized to be employed. Jumping ahead, again, the consequences range as well, not only for the employer, but the foreign worker. So here we see some sections of the Immigration and Refugee Protection Act that pertain specifically to the foreign worker. A foreign worker who's been found to be working illegally in Canada could face detention or deportation removal proceedings, being deported from Canada. Finding of working illegally could result in problems entering Canada in the future, as well as, whether that's on a temporary basis or as well in difficulty in applying or obtaining their permanent residency. And we also noted misrepresentation can lead to a 5-year ban. So a foreign worker who is, any person who's found to have misrepresented themselves in an immigration application could find themselves with a 5-year ban on further attempts to enter Canada. So, as you can see, hopefully quite serious consequences, not only on the employer side, should they wish to continue hiring foreign workers on a continuous basis, but also for the individual and the person that they're hiring. If they're found to have been non-compliant, working in Canada illegally, then that could have some very serious consequences. And many of these programs have they're entered into with a view to permanent residency. So Atlantic Immigration Pilot is a good example, or the Provincial Nominee Program. People, foreign workers coming to Canada to work while the processing of their permanent residency application is ongoing. If they were guilty of misrepresentation, then that would obviously derail their future permanent residency application. So, as we've, gone over, I guess, some of the risks for the employers, then our goal today is to review what we consider 5 key compliance best practices and notes to ensure that you're covered as an employer and how can you avoid some of the consequences that would be available to you if you were non-compliant under the Immigration Refugee Protection Act. And just as a brief caution here, obviously our key principles that we'll talk about today are with respect to immigration specifically and not with general employment standards. So employers are still expected to comply with labor and employment laws and principles, employment standards, pay deductions, etc. These are just a few examples. And that is separate and apart from the immigration process and separate from any of the immigration compliance issues. And so our key principles today are with respect to compliance under the immigration law. So our first best practice, number 1 here, is know the rules. Be familiar with what it is that is expected of you as an employer. And in order to do so, where can you find the rules? Well, the key legal sources are the Immigration Refugee Protection Act, as I've mentioned several times, the regulations which form part of the Act. There are also departmental manuals and foreign worker manuals available from the government on their websites, and those are all key sources in order to familiarize yourself with those sections that we've quoted in earlier slides and the sections of the Acts that apply to you as an employer. In addition to the key sources, there are key government agencies that you'd be working with as an employer or that you would be expected to run into throughout the process when employing a foreign worker. And those key agencies include Canada Border Services Agency, CBSA, obviously at the ports of entry. They're also responsible for immigration enforcement and removal. IRCC, Immigration, Refugee and Citizenship Canada, formerly known as CIC or Citizenship and Immigration Canada. So you may still see references to CIC, but the name now is Immigration, Refugee and Citizenship Canada, and they're responsible for immigration applications, the processing of those applications. And then, as I've noted, ESDC, which is Employment and Social Development Canada or Service Canada, and they're responsible for these labor market impact assessments, the LMIAs, and of course then the LMIA enforcements and audits related. In addition to the key sources and agencies, when it comes to knowing the rules, it's important to know the basic rules with respect to employing a foreign worker, and that starts with the Immigration and Refugee Protection Act. Section 8.1 states, a foreign national may not enter Canada to work without first obtaining a work permit. So this is just an example of what a work permit looks like. You should be familiar with what it looks like and also be prepared to request to see the work permit of any foreign worker. Just jumping to the next slide, the work permit, also known as a work visa. So in other countries outside of Canada, you may hear reference to work visa or from foreign workers themselves, but it's your basic immigration instrument for the foreign workers. It's an essential document for anyone who is not a citizen or a permanent resident of Canada. So in order to work, as the definition states, a foreign national must have this work permit in order to come into Canada to work. There are some exceptions under the Act. So Section 186 of the Immigration and Refugee Protection Act sets out some of the exceptions to obtaining a work permit. In these circumstances, a person can come to Canada without a work permit. There are a lengthy list under 186, but these are just a few examples. So with respect to students, if a person is a holder of a study permit and is employed as a full-time student, then the program which they're enrolled is a post-secondary academic program, then they may be permitted to engage in full-time work during a regularly scheduled break. Although they're here as a student, while they're on a regularly scheduled break between semesters, they'd be permitted to work. Or they could work no more than 20 hours, so on a part-time basis during the regular academic session, for example. Performing artists, guest speakers, business visitors are also additional examples who are coming in. And the key piece with the business visitors in particular is, for example, someone coming in for a business meeting or to conduct after-sales service is that these are people who have no intention to enter the Canadian labor market. So the activity is international in scope. Their primary remuneration remains outside of Canada, but this is a person, employed by a foreign company, for example, who has to come for a short term and attend a business meeting. The after sales service is another example of one that's an exemption used quite frequently. Situations where a person is seeking entry to repair or service specialized equipment that was purchased or leased outside of Canada, as long as that service is being performed as part of the original sales agreement. So a Canadian company has purchased something from a foreign company as part of the original sales agreement. There's some repair services expected, and then that foreign company is sending someone specifically to conduct that specialized after-sales service. And so beyond those, certain exceptions, then of course we're back at the basics, which is that a work permit is required. Now the question then becomes, what is considered work? If a foreign national may not enter Canada to work without first obtaining a work permit, how do we determine whether that person is working and what is considered work? Well, work is defined in the Act as an activity for which wages are paid or commission is earned, or also an activity in direct competition with activities of Canadian citizens or permanent residents in the labor market. So the key piece, of course, of that definition is the activity for which the foreign person is coming to Canada. And that is the activity of the person and not the classification of the arrangement itself. So we must do a bit of an analysis to determine whether the activity that they're conducting is considered work. Now, one example of an activity that this type of analysis would have to be performed is volunteer work. Often volunteers could probably be considered to be doing work because the focus is on their activity, and it's not enough to simply classify a relationship as work, as volunteer, It matters what that person is actually doing. And if that person is doing something that typically a Canadian citizen or permanent resident would be expected to receive remuneration, we can't get away from it meeting the definition of work simply by calling it a volunteer activity or having them perform it on a volunteer basis. They would still be expected to have a work permit in order to conduct that work. And that's just one example. And then Megan, I'll pass it over to you for some further look at compliance best practices.
Sure. So, hi everyone. So, just to add to a little bit the volunteer piece, I always give the example of someone who's working in the soup kitchen. If you're working in the soup kitchen and you're not being paid, well, a Canadian who's normally working in a soup kitchen or volunteering in a soup kitchen wouldn't be paid either, so that would be okay. But something else, if you're, teaching classes but not being paid for it, well, that's something that would normally be paid. So you'd normally, it would be considered being entering into the labor market. So that wouldn't be allowed. So to move on, one other thing we need. Oops, how do I get back? There we go. So went too far. So moving on, the other thing I guess what I wanted to discuss next is the actual foreign worker process. Sorry, we're getting a little bit mixed up here. I think it's a little bit. And I'm going back. How do I get back? Sorry, everyone. Let's just.
You can just go. Yeah.
This way? Seems to be going in the wrong direction.
Okay, use your arrow keys.
Don't see any arrow keys here.
Here, let me see if I can. Just 1 sec.
Back to the process. Sorry, everyone.
1 sec here.
Some technical difficulties. So we want to be on page 21, maybe, the temporary foreign worker permit process.
Megan, on your keyboard, use your arrow keys.
My keyboard. Okay, let's see if we can get back there. Whoa, we got really far ahead of ourselves, didn't we? Here we go. Okay, hopefully this has stopped here. Okay, good. So sorry about that, everyone. So the temporary foreign worker process, as well as the rules. Okay, we want to learn about and know about the temporary foreign worker process. So how do you actually get a work permit for a foreign worker? And generally speaking, normally, okay, in order to obtain a work permit for someone that you want to employ from a foreign country, then you have to first obtain a document called an LMIA, Labor Market Impact Assessment. Okay, this document, it requires that you advertise. Normally, it requires that you advertise first for 30 days. Okay, you pay a $1,000 processing fee. Okay, you demonstrate that there are no Canadians or permanent residents qualified to fill the position. Okay. And then, depending on the wage that you're going to be paying the foreign worker, the processing time can vary from anywhere from 10 business days to 6+ weeks. The processing times vary by region as well, so they're generally a little bit quicker on the East Coast and a little bit longer over on the West Coast. Once the LMIA is granted, okay, then you can use this usually what you would do then is you would give this to your foreign worker, and the foreign worker would then have to apply for a work permit. Now, if the foreign worker is from a visa-exempt country, okay, then they can apply for the work permit at the border. If they're from a visa-requiring country, then you have to that individual has to apply for the work permit either through either online or through one of the VACs, Visa Application Center, responsible for their home country. There we go. Okay, this program, the temporary foreign worker program, under which we get labor market impact assessments. There are some, there are many nuances. Okay, I won't get into all of them here today because there are quite a few of them. But there are a number of things to be aware of, and one of them is that there are some advertising exemptions. Okay, so there are some situations whereby you don't actually need to advertise, so you can still submit the LMIA application, but you don't need to advertise first. One of those would be under this new global skills strategy. Okay, where if you are hiring someone in one of the listed designated occupations, then you can bypass the requirement to have to advertise. Also, if you're supported by one of the stream's designated partners, then you may be able to bypass the requirement to advertise as well. I mentioned this earlier, but there is a 10-day processing time in most provinces for individuals for occupations where you will be paying them a wage range or a wage that is within the top 10% of the earners for that particular province. Okay. Some of the other things to consider when you're applying for an LMIA are a transition plan that is required for high wage positions. Okay. And also that there are some unique and the differences between applying for high wage versus low wage positions. There are actually two separate types of applications. So moving on to the International Mobility Program, I want to make sure that we understand that there's a unique difference between the Temporary Foreign Worker Program and the LMIA, okay, and the International Mobility Program, IMP, okay. The LMIA requires that you advertise, okay, well, and obtain an LMIA before you, or the Temporary Foreign Worker Program requires that you advertise, obtain your LMIA, and then use your employee, can use that to hire to obtain a work permit. Well, there is an exemption to even requiring an LMIA. There are a number of them, okay, and I haven't listed them all here, but these are some of them, and these fall under the International Mobility Program, okay. So these are situations whereby you may not need an LMIA if the type of occupation you're applying for meets one of the definitions, okay. Many of them are due to international agreements under NAFTA, GATS, CETA, okay, but they actually also include work permits under the Provincial Nominee Program or under the Atlantic Immigration Pilot Program. So the process for this type of work permit, okay, for the process for the IMP work permits, okay, is slightly different than the process under the Temporary Foreign Worker Program for the LMIA, okay. So here, what you do as the employer, you have to set up an account online, okay, with the Canadian government, with your CRA, with your business CRA number. Here, what you do is if you want to hire a foreign worker, you have to submit what we call an online offer of employment. This online offer of employment will ask you for information on things such as your business information, the temporary foreign worker information, and most importantly, working conditions. So the wage, the hours, benefits, location of employment, vacation, that kind of thing. When you submit this online offer of employment, almost immediately through your account, you'll have to pay a $230 fee, of course. When you submit this online, you'll almost immediately be generated an online offer. Okay, a receipt. You'll get a receipt for $230, and you'll get an email with an 8-digit A number therein. With this, okay, you send this and any other supporting documents that are required. Now, all those different types of work permits that I just listed, under GATS, NAFTA, CETA, Provincial Nominee Program, they all require slightly different documentation. So I won't go over which each one of those uniquely requires, but depending on what type of application you're applying for, you'll need documentation for that particular type of application. But you'll always need this online offer of employment with the receipt and the 8-digit A number. Okay, so you will have to give this to your worker. Okay, and if they're from similarly, if they're from a visa exempt country, okay, then they can apply for a work permit right at the border. If they're from a visa requiring country, then they'll have to apply for the work permit either similar to they would have to under the temporary foreign worker program. They would have to apply for their work permit either at a Canadian embassy abroad through a VAC, their nearest VAC, or they can apply online. So the next thing I want to speak about is the work permit review. So it's important that you get familiar. I know that Morgan had this the work permit up earlier, and that's good because it's important that you get very familiar with this document. Okay, it's important that you understand what this document means and what's in it. So the types of things that are in this document and that you need to be looking for are things like the name, and you'll see here I have them circled. So the name. Things like their personal information, their country of birth, okay, their passport number. You'll also have to look here for the date of issue and the date of expiry, okay. The employer, if it's a closed work permit, so if it's a work permit that you helped get either, like I said, under the temporary foreign worker program or under the international mobility program, then it will have your employer name there. It'll also have the location of employment, the occupation, okay, and also any other notes caveats, conditions on the work permit that may or may not apply for your worker. A lot of the time, you'll see prohibited from working in a health occupation, and that's because most occupations where you're going to be working in the health field do require that you obtain a medical first. So now going on to the actual LMIA, so the Labor Market Impact Assessment or the online offer of employment. So you want to understand what these two documents are and what they mean, okay? So remember we spoke about the LMIA under the Temporary Foreign Worker Program. We spoke about that first. That's the first document you see there. The overlapping document there next to it, that's the online offer of employment. So that's what your online offer of employment looks like when you're submitting it. Once you've created your account and once you've gone in and submitted all your information. So it's important to know these, understand them, and make and you'll see as you'll see in a moment, you're going to want to make copies of them and be familiar with them. So what I'm going to be speaking right now with for the next couple of slides is it pertains to both the LMIA and the LMIA under the Temporary Foreign Worker Program and also the online offer of employment under the International Mobility Program. They're both separate types of applications, but when it comes to compliance, your obligations are the same. Okay, so it's important that whether you filed an LMIA or whether you filed an online offer of employment, that you understand what's in them and that you are that you make sure that you abide by them, okay, by whatever information you've provided therein. So whether you file, like I said, whether you have the LMIA or the online offer of employment, you want to make sure that they're consistent with the work permit. So the information provided in the work permit that we just discussed, you know, they're going to want to see, you're going to want to make sure that whatever is in those documents are also consistent with the employment contract that you provided for your employer. And also you want to make sure that, and this is just as important or perhaps more important than anything, is that you that any wages, all the working conditions listed in either that LMIA or online offer of employment are consistent with what you're actually paying the foreign worker, okay? Because this is what you'll be audited on later down the road. So these will include, you know, the job duties and location of employment, the job description, occupation, the hours, benefits, wages, vacation, all that kind of stuff. So the next thing we want to look at as well is the employment contract review. So you want to make sure that, again, the online offer of employment or your LMIA is consistent with everything that's in the contract. And the reason for this is because when your worker applies for the work permit, when the immigration officers are reviewing the application package, they're going to want to see consistency. They're going to want to see that everything's, you know, that everything's buttoned up. So very important that everything is consistent, not only obviously with what you're paying them, but with what's in the contract and what's listed on those online offer of employment or LMIA, whatever the case may be. So one of the last things we want to discuss here today is, of course, you know, maintaining records. When you file an online offer of employment or an LMIA, you can be, I know that Morgan discussed this a little bit earlier as well, but you can be audited. It's actually not more likely a matter of when you'll be audited, not a matter of whether you'll be audited. The vast majority of employers who hire, you know, frequently hire foreign workers will at some point get audited, okay? Most of the time they are random, and it's important that any documents that you have you maintain for 6 years, because you can get audited for up to 6 years after the date of receipt of your LMIA or online offer of employment. So one of the things we always recommend that people do is that you keep a file on every worker, okay? And in this file, you should have a number of things, okay? I mean, first and foremost, have a copy of the work permit, a copy of the LMIA or online offer of employment, whichever one it may be, okay? A copy of the employment contract, of course, but also the things that ESDC will look for if they're conducting an audit is they will be looking for things such as payroll records, timesheets, filings with CRA. They're going to want proof, you know, that you are paying the foreign worker what you have indicated that you are paying them, that you're paying them in the same capacity, okay, that they're working the same amount of hours that you said that they would be working, and also at the same location. And inconsistencies with any of these things could ultimately result in a finding of noncompliance. So now we have, you know, just a brief recap, okay, of the 5 best compliance practices, okay. The first, of course, is know the rules/processes, okay. So understand what the processes are and what the rules are, okay. Take a look at that work permit and review it, okay, and understand it. Understand and review the LMIA or the online offer of employment, whatever it may be. Make sure it's consistent with everything else. Look at the employment contract and make sure it's consistent as well. And then, of course, keep copies of all of these things, maintain records, and keep them in a safe place. So that's everything we had for our substantive portion of the webinar today. We are happy to answer questions. I will just look at my email now to see if I have any. And I believe, okay, so the first question I have is excuse me, what happens if I'm audited and I just gave my employee a large raise? Well, I get this question quite frequently, and the reality is that this is not good. Okay, we don't want that. When you file either an online offer of employment or an LMIA, okay, you are committing in that document that you are paying that worker that wage, okay, for the foreseeable, you know, for the duration of that work permit, okay. If you gave them a raise or promotion, then you are audited, then you will most likely be found non-compliant. Now, the reason why people often don't understand why that is, and the reason why is because because ESDC, they want to make it, obviously they want you to recanvass the labor market to see if maybe a Canadian would have applied for that position had they known about that position or that raise or that, that different position that was being offered. So the idea is that when you're given that LMIA, it's for that specific occupation that was advertised using that exact wage. Okay, so the idea is that you have to re-advertise and refile an LMIA if you want to give someone a raise and or promotion. So what I often will tell clients when they when they are they're first getting the LMIA, if you plan on keeping this employee for a while, they're good, you want to keep them on, and you think that you might be giving them a large raise or a promotion in the foreseeable future, well then what I will tell them is there are ways to get permanent residency quite quickly. So let's get them permanent residency as soon as possible, so that you can, because once this person obtains permanent residency, then you're no longer bound by the terms of the LMIA. The next question, now Morgan, do you, I believe there's a couple questions here that you might want to answer. Do you want to go ahead and answer a couple of those?
Yeah, sure, I can take one here. Okay. One of them, how does Service Canada determine whether it will inspect an employer for compliance? So there are the regulations under the Immigration and Refugee Protection Act. The accompanying regulations set out circumstances for an inspection of an employer, and there are actually three circumstances or three triggers for an inspection. Those are known past non-compliance, so an employer who has previously been found non-compliant either under the Temporary Foreign Worker Program or the International Mobility Program, then that could trigger future inspections. Number two is random selection. So there are, and Meghan alluded to this, verifications of employer compliance simply based on a random selection model. And then the third trigger under the regulations is reason to suspect. So if ESDC has received information relating to an employer specifically that gives an officer reason to suspect that they're not complying, whether that's could be an anonymous call or letter, could be simply information they've received from Canada Border Services, kind of regardless of how that information comes to them, if they then have a reason to suspect that employer, that would trigger an inspection by ESDC.
Okay, guys, I have a couple of other questions here. So good ones, actually. So the next question I have is, if someone already has an open work permit for Canada, to work in Canada, do we need to complete an LMIA? And the answer is no. So if someone has an open work permit, then the open, and by the way, an open work permit means that the work permit has the person's name on it and obviously has an expiry, issue date and expiry date, but it doesn't have a location or a employer on it, then that's an open work permit. So that's why it's important to look at the work permit and to inspect what kind of conditions are on there and to know and understand that well. But if it's open, then yeah, you can employ that worker and you do not need to get an LMIA. However, look at it carefully because and look at the expiry date, because if the expiry date is coming up soon, then you will need to extend that, and it's depending on the unique circumstances of that person, it's usually difficult or impossible, in most cases not possible, to extend an open work permit. Some incidences where you would have an open work permit are, for example, postgraduate work permits are open work permits. So somebody who's come to Canada as a student and graduates, well, they are eligible for what we call a postgraduate work permit that is valid for the duration of their studies up to a maximum of 3 years. So some people might have a 3-year open work permit and based on their graduating from a Canadian school. So that is one situation. Another situation is if there's a foreign person comes to Canada as a student and they have a spouse. Well, the spouse is eligible for an open work permit for the duration of that person's studies. So that could work as well. Or if somebody is in Canada and a foreign person is in Canada and they're married to or a common law with a Canadian citizen and they have a pending inland spousal sponsorship application pending, well then the foreign spouse is eligible for an open spousal work permit that's valid for 1 year as well. So those are situations where you might see an open work permit. But yeah, the answer to your question is look at it closely to make sure that there's no employer on it, But yeah, it is possible. You don't need to obtain an LMIA. You can use that person can work for anybody on their open work permit. The other question I have here is, with the LMIA application, do you need to have the candidates ready to hire at the time you do the application, or can it be an open application? The application form itself is confusing as it asks for names. That's a good question. So the answer is that no, you do not need to have people listed there, okay? You can actually ask for an unnamed LMIA, okay? Once you get, so when you fill out your application forms, in the space where it asks for the name, just say unknown at this time. When they issue you the positive LMIA, which you have 6 months to use, by the way, the LMIA, you'll have 6 months to use it. All you need to do is contact ESTC. Try to give them as much notice as possible, but contact ESTC when you have found your candidate, and you can have the person's name added to your LMIA then. Just be careful, though, because the LMIA that you've obtained is for a specific wage, remember, and for a specific occupation. So if the person that you hire, maybe you want to pay them more, then you have to refile the whole LMIA, because that LMIA is attached to a certain wage. You can't change any of that once it's been approved and assessed. So but I hope that helps you, though. That should be help. So the answer is that no, you don't need to have the names. You also can actually change the names. That is possible as well. So let's say you have an LMIA for somebody, but that doesn't work out. Well, if you find somebody new, as long as it's the exact same working conditions, same wage, same occupation, well, then you can actually inform, as long as it hasn't been used to obtain a work permit, you can inform ESTC, and they should be able to, they will change the name on it for you. We've never had any issues with that in the past. Let's see. I have a question here. Is it better to apply for a work permit independently of the AIPP or apply via the AIPP? I asked because I submitted an application through AIPP on August 10th. On August 10th, asked for support for the work permit, and the file still hasn't been assigned to a caseworker. Okay, so there are a couple of things I guess I'm kind of missing from this one. So usually, I'm assuming that I'm assuming that you're applying for a work permit, sorry, the AIPP, by the way, everyone, is the Atlantic Immigration Pilot Program. I'm assuming that this person is wishing to hire someone from outside of Canada, so they're not currently in Canada, and you're wondering if it's better to apply for the work permit independently of the AIPP or apply via the AIPP. It really depends on your circumstances. If it's a high, and it's a good question, if it's a high-skilled position, so if this is for someone who's going to be paid, above the 10% of fee earners for the province. So let's say it's in, it's in Newfoundland, and the top 10% of fee earners from Newfoundland, I think the top 10% is about $82,000 a year. So if you're going to be paying them more than $82,000 a year, it's a high-skilled position. Because you get an LMIA in 10 days, then I would recommend doing the LMIA. But if it's not, if it's for a lower skill position, then you're looking at a long processing time for the LMIA, longer, not long, but longer, easily 2 months, whereby you can, so it's hard for me to answer this question without really, discussing, having a discussion about it. It's a little bit too generic. But if you want to contact us offline, you have our contact our service, our client service email, or contact me if you can find my email, Meghan Feltz. You can find my email online. You can send me an email, and we can see if we can get together, and I can answer your question for you. I believe Laura just sent me another question. I don't see it though. Let's see. There's another question here about fees and that kind of thing. If you have any questions about our fees and things like that, feel free to send us an email as well. You can contact me or Morgan. You can contact me online. I'm just looking at. You can contact us online. You can send us an email to our email address or to our client service inbox. So another question just came in. Okay, what would happen if down the road the job tasks are changing? This is a good question as well. And the answer is, you have to get a new LMIA. Generally speaking, you have to get a new LMIA. You see, when you apply for the, like I said before, when you apply for the LMIA is for a set type of occupation. Okay. Now, the way to know for sure whether you've been non-compliant or not is, well, when you apply for an LMIA, okay, the Canadian government has what we call a NOC code, so National Occupation Classification. Okay, they have NOC codes for every different occupation in Canada. Okay, and so when you apply for an LMIA, whether you realize this or not, well, when you put in the job duties and inform and indicate what the job title is, okay, you're automatically classified under a NOC code, NOC. Okay. And the ESDC officer will actually automatically assess you as under a specific NOC code, whether you realize it or not. So if the job tasks are changing, and let's say 6 months down the road, the job tasks change slightly, okay, or they change a little bit, but they're still related to that job. So let's say that if you look at that NOC code that you were submitting under, if those tasks would still be considered part of that NOC code, then you're most likely okay. But if it realms outside of that, then you're going to be non-compliant because you're a different job. You're going to be doing a different job, which would possibly require a different prevailing wage. So you really have to be careful with that. So this is one of the reasons why it's so important to know the rules, know and understand the LMIA. When you're submitting an LMIA, understand what the premises are and what the conditions are and what you're actually, what you're filing, because and understand the NOC codes as well. That's very important because that'll help you determine down the road whether you're still within that NOC code or whether you're not. That's a good question. So if there are no more questions, I don't see any more come in, then that would conclude it for today. You can feel free to contact us either through our client service or you can email me directly. I'm happy to set up consultations or to meet with people offline. Thank you so much and have a great day. Don't see it though. Someone have another question come in? Here we go. Okay, one more question. Sorry about that. I see it here now. What are the main differences between a TFWP and an IMP? Would the application process be different for the employer and the foreign worker? Yeah, so they're actually quite different. And I mean, I did go over them in the slideshow, but it's quite convoluted. So this is kind of a loaded question, but it is, there are some significant differences. The main difference between the TFWP and the IMP is the TFWP is much longer. So the Temporary Foreign Worker Program requires that you apply for an LMIA, okay? Now the LMIA sometimes requires advertising, sometimes it doesn't, but it still requires that you go to ESDC and you get this document, okay? And then with that document, you can file a work permit application. And again, whether you're visa exempt or not, you can, depending on whether you're visa exempt or not, you can either apply at the border or apply it at a Canadian embassy abroad, okay? So, but the key difference with the Temporary Foreign Worker Program is that this is the LMIA process, okay? Under the IMP, the International Mobility Program, you're exempt from having from needing an LMIA. So you don't need an LMIA at all, but what you do need to do as an employer is you need to apply for, you need to set up an online account and submit an online offer of employment, which literally can take like a couple of minutes. So it's much, much less cumbersome in that sense, okay? And then with that, and of course any other essential work permit application documentation, your worker can either apply at the border or they can apply apply at the border if they're visa exempt, just like under the TFWP, okay? They apply at the border if they're visa exempt, or they apply it at a Canadian embassy abroad if they're from a visa requiring country. So the main difference is that the TFWP, the Temporary Foreign Worker Program, is the LMIA regime. The IMP, the International Mobility Program, is an LMIA exempt regime, okay? So it means it's faster. You don't have to go through the LMIA process. You can apply online without having to advertise. Apply using your online offer, using your online account, takes a few minutes, and you do not need to advertise. Okay, a good question. Can you hire someone with an open work permit over a Canadian? The answer is yes. If the person has an open work permit, there's no trouble. You won't get in trouble because they have an open work permit, as long as it is a genuine, valid open work permit. Any more questions?
Hold on, I think we've got one more coming in. Just 1 second here.
Okay.
I think we're good. Anyone else have a question? Please feel free to put it into the question box. That looks like it's it on my end.
Excellent. It was really, well, thank you everyone for joining us here today. We really, really appreciate everyone coming out. And if you have any other questions later on, then you can contact us directly. We're happy to help. Have a great day, everyone.
Thanks, everybody.